Hi friends, this is CMA Deepika, Bhugra, Prasad, insolvency professional. The Honorable Supreme Court has ordered liquidation of Bhushan Power and Steel Limited under the Insolvency and Bankruptcy Code 2016, rejecting the resolution plan of JSW Steel, finding it to be non-compliant with the code. Friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the code IBC 2016 and to navigate through the intricacies of its proceedings. Let us today, friends, discuss this much talked about case of Bhushan Power and Steel Limited. So this is the case of KalyaniTranscoV versus Bhushan Power and Steel Limited and others, which was decided on the 3rd of May, 2025 by the Honorable Supreme Court of India. Now, what were the issues before the Honorable Court? Who would be an aggrieved person under Section 61 or Section 62 of IBC? Can an SRA challenge own approved resolution plan under Section 61, subsection 3 of the IBC? The issues related to the requirements under Section 29A of IBC. Whether the NCLAT has any powers of judicial review over the decisions taken by the statutory authority under the PMLA. Clarity on the CIRP time limit under Section 12 of IBC. Role of the commercial wisdom of the COC. Role of the resolution professional while conducting the entire CIRP. Implementation of the resolution plan by the SRA. Non-compliance of the mandatory provisions and misuse of the power of process of law. Binding nature of the NCLT's approved resolution plan. And the mandates given in the CIRP regulations, which have to be strictly complied with by all the stakeholders as well as by the authorities under the IBC. Now let us see the factual background of this case. Punjab National Bank initiated CIRP proceedings against Messrs. Bhushan Power and Steel Limited before the NCLT under the provisions of the IBC Code. It was admitted on 26th of July 2017. The RP admitted claims worth rupees 47,204 crores in respect of the financial creditors and rupees 621 crores in respect of operational creditors. Now, the prospective resolution applicants were JSW Steel, Tata Steel, and Liberty House, and they submitted their respective resolution plans. The plans were evaluated by the COC as per the evaluation metrics formulated by it, and JSW Steel was found to have scored the highest in terms of the said evaluation metrics. However, the COC did not declare H1 and H2. The COC approved the consolidated resolution plan as amended by the addendum letter of JSW by e-voting by the requisite majority. On 14th of February 2019, the RP filed an application for approval of the resolution plan submitted by JSW Steel before the Honorable NCLT. Now, meanwhile, the CBI on 5th of April 2019 registered an FIR against the corporate debtor, its directors, and others under Section 120B and Section 13.2, read with Section 13.1D of the Prevention of Corruption Act. Basis the said FIR, the Enforcement Directorate registered the case on 25th of April 2019 for the offences under the PMLA 2002. The NCLT-wide order dated 5th of September 2019 dismissed the company applications filed by the erstwhile directors and approved the resolution plan of JSW. The successful resolution applicant JSW challenged some of the conditions mentioned in the said order passed by the Honorable NCLT, approving its own resolution plan by filing the appeal under Section 61 of IBC. After the approval of the plan by the NCLT, as aforesaid, the ED passed a provisional attachment order on 10th of October 2019 under Section 5 of the PMLA. On 14th of October 2019, the NCLAT stayed the PAO, the said PAO having been challenged by JSW before NCLAT, as well as the resolution plans so far, it related to the payment of the creditors. On 17th of February 2020, the NCLAT approved the judgment dated 5th of September 2020, passed by the NCLT, subject to the modifications and clarifications made by it in its impugned judgment. Appeals against the order of the NCLAT were filed in this case. There is no stay against the implementation of the resolution plan. Now, what were the issues before the Honorable Supreme Court? First, who is an aggrieved person under Section 61 or Section 62 of IBC? As per Section 62 of IBC, the issue of maintainability of the appeals has to be decided by the court, considering the position of the parties at the time of the institution of the appeals. Once the CIRP is initiated, the proceedings are no longer restricted to any individual applicant creditor or to the corporate debtor, but rather they became collective proceedings in rem, where all the creditors and the ex-directors would be necessary stakeholders. Therefore, the appellants, who are the operational creditors, and the erstwhile promoters, being important stakeholders, and whose company appeals have been dismissed by the NCLAT, while the impugned judgment would certainly be the persons aggrieved entitled to file appeals before this court under Section 62 of the IBC. Now, the second issue is Section 61, subsection 3 of the IBC. Can SRA challenge the approved resolution plan? It seems that JSW was aggrieved by some of the conditions imposed by the NCLT while approving its plan. However, for filing such an appeal under Section 61, the grounds specified in subsection 3 thereof must exist. Now, when the resolution plan of JSW Steel was approved, it was binding to all the stakeholders, including the SRA, that is JSW, as per Section 31, subsection 1. And the SRA could not have filed the appeal before the Honorable NCLAT when none of the grounds stated in Section 61, subsection 3 existed. However, the NCLAT, while the impugned judgment dated 17th of February 2020, not only entertained but also allowed the said appeal of JSW, which was not legally maintainable, also modified the conditions which were not suitable to JSW and dismissed all the other appeals filed by the operational creditors, the ex-promoters, and the state of Odisha. Now, the next issue was NCLAT's directions on issue which was neither the subject matter before the NCLT nor before the NCLAT. It was not clear as to how the directions, such as declassifying the corporate debtor company as a promoter of any other company or entity, etc., could have been given by the NCLAT in the appeal filed by the JSW under Section 61, which was filed challenging only the conditions imposed by the NCLT, while approving the resolution plan of JSW under Section 31. The next is the mandatory requirement under Section 29A of IBC. Since the eligibility or ineligibility of the resolution applicant to submit the resolution plan goes to the root of the matter, it was incumbent on the part of the RP to verify and certify that the contents of the mandatory affidavit filed by the resolution applicant JSW in respect of Section 29A were in order. In the present case, the RP had not submitted the compliance certificate in the prescribed Form H of the schedule while submitting the application before the NCLT, seeking approval of the resolution plan under Section 31(1), read with Section 30, subsection 6 of the IBC. Now, whether the NCLAT has any powers of judicial review over the decisions taken by the statutory authority under the PMLA. Now, Section 32A was inserted in the IBC with effect from 28th of December 2019, which pertained to the liability of a corporate debtor for an offence committed prior to the commence of CIRP. The NCLAT held in the impugned judgment dated 17th of February 2020 that in view of Section 32A(1)(2) of IBC, the ED or the investigating agencies did not have the powers to attach assets of the corporate debtor once the resolution plan had stood approved, and that the criminal investigations against the corporate debtor also would stand abated. The NCLAT also declared that the attachment of assets of the corporate debtor by the ED pursuant to the order dated 10th of October 2019 was illegal or without jurisdiction. The jurisdiction and powers of the NCLT and NCLAT are well circumscribed under Section 31 and Section 60 so far as NCLT is concerned, and under Section 61 of IBC so far as the NCLAT is concerned. Neither the NCLT nor the NCLAT is vested with the powers of judicial review over the decisions taken by the government or statutory authority in relation to a matter which is in the realm of public law. It was held by a 3-judge bench in the case of Embassy Property Developments Private Limited versus the state of Karnataka by the Honorable Supreme Court of India that Section 60, subsection 5 speaks about any question of law or fact arising out of or in relation to the insolvency resolution, but a decision taken by the government or a statutory authority in relation to a matter which is in the realm of public law cannot be brought within the fold of the phrase arising out of or in relation to the insolvency resolution appearing in section 60 subsection 5C of IBC. The Prevention of Money Laundering Act 2002, that is the PMLA, being a public law, the NCLAT did not have any power or jurisdiction to review the decision of the statutory authority under the PMLA. Now, the next issue is for the CIRP time limit under section 12 of IBC. Now, there is a model timeline prescribed for the completion of CIRP proceedings in Regulation 40A of the Regulations 2016. As per Regulation 39(4), also the IRP is required to submit the resolution plan approved by the COC to the adjudicating authority at least 15 days before the maximum period for completion of CIRP under Section 12. As per Section 12, subsection 2, the RP was required to file an application to the adjudicating authority, meaning thereby it was incumbent on the part of the RP to bring to the notice of the COC about the expiry of 180 days and seek instructions in that regard from the COC. However, no such application was filed by the RP as contemplated in Section 12, subsection 2, seeking extension of time for the expiry of 180 days, nor he had submitted the resolution plan approved by the COC before the maximum period for completion of CIRP prescribed under Section 12 as contemplated in Regulation 39(4) of the regulations. Now, the consequences of not receiving the resolution plan under Section 30, subsection 6 before the expiry of CIRP period or the maximum period permitted for completion of the CIRP under Section 12 have been laid down in Section 33, according to which the NCLT had to pass an order requiring the corporate debtor to be liquidated in the manner laid down in Chapter 3 of the IBC. Now, the role of resolution professional while conducting the entire CIRP. The Honorable Court held that it cannot be said that as per the scheme of the Code, the role of the RP while conducting the entire CIRP is not only of an administrative or facilitative, but is also of an invigilator to ensure that the CIRP proceedings are completed in a time-bound manner for maximization of the value of assets in order to balance the interest of the stakeholders, and that there is compliance of all mandatory provisions under the Code during the course of the entire proceedings. RP must also comply with all the duties as envisaged under Section 17, 20, Section 30, subsection 2, and Section 30, subsection 3. It is also required to be noted that as per Section 31, subsection 1, the adjudicating authority is empowered to approve only such resolution plan approved by the Committee of Creditors under Section 30, subsection 4, which meets the requirements as referred to in Section 30, subsection 2. The next issue is non-compliance of the mandatory provisions and the misuse of the process of law. The Honorable Court further held that in the instant set of appeals, the respondents, that is JSW, COC, and the resolution professional have sought to sweep many seminal issues under the carpet to cover up gross violations of the provisions of the IBC and of the Regulations 2016 at every stage of the CIRP initiated against the corporate debtor. It was further held that there is nothing on record to show as to how, when, and by whom the effective date as contemplated in the resolution plan was extended. If the effective date was extended by some lenders claiming to be part of COC, which had become functus officio and which had no authority to do so, any payment made or equity infused by JSW under the garb of such decision cannot be vindicated by the court. The Honorable Court held that mandates given in CIRP regulations have to be strictly complied with by all the stakeholders as well as by the authorities under the IBC. The further issue was with the commercial wisdom of the COC. The position of law propounded by this court is that the commercial wisdom of the COC means a considered decision taken by the COC with reference to the commercial interest, the interest of revival of the corporate debtor and maximization of its assets. The court also held that though the commercial wisdom of the COC should have been given the primacy in any adjudicatory proceedings, the changing stance of the COC from time to time during the course of proceedings, right from the holding of meetings for approving the resolution plan of JSW till the final hearing of the present appeals, has led this court to believe that the COC also has played a very dubious role in the entire CIRP. Such a contradictory stand taken by the COC at various stages of proceedings clearly proves that COC had played foul and had not exercised its commercial wisdom in the interest of the creditors. Further, the implementation of the resolution plan by the SRA. Merely because the code is silent with regard to the phase of implementation of the resolution plan by the SRA, neither the tribunal nor the courts should give excessive leeway to the SRA to act in flagrant violation of the terms of the resolution plan or in a lackadaisical manner. Further, the binding nature of the NCLT's approved resolution plan. The resolution plan, after its approval by the adjudicating authority, that is NCLT, under Section 31, is binding not only to the corporate debtor, its employees, members, creditors, and the government authorities, but also to all stakeholders, including the successful resolution applicant itself. The Honorable Court said that it may be noted that any contravention of the terms of the approved resolution plan by any person on whom such plan is binding under Section 31 is liable to be prosecuted and punished under Section 74, subsection 3 of the IBC. So, friends, we conclude. As per the Honorable Court, the RP had utterly failed to discharge his statutory duties contemplated under the IBC and the CIRP regulations during the course of the entire CIRP proceedings of the corporate debtor. The COC had failed to exercise its commercial wisdom while approving the resolution plan of the JSW, which was in absolute contravention of the mandatory provisions of the IBC and CIRP regulations. The SRA, that is JSW, after securing the highest score in the evaluation metrics in the 18th meeting of the COC, submitted the revised consolidated resolution plan with addendum under the garb of complying with the amendments made in the CIRP regulations 2016 and got the same approved from the COC. However, JSW, even after the approval of its plan by the NCLT, willfully contravened and not complied with the terms of the said approved resolution plan for a period of about 2 years, which had frustrated the very object and purpose of the IBC, and consequently had vitiated the CIRP proceedings of the corporate debtor, Bhushan Power and Steel Limited. Further, the resolution plan of JSW as approved by the COC did not conform to the requirements referred to in Section 30, subsection 2, the same being in violation and contravention of the expressed provisions of the IBC and the CIRP regulations. The said resolution plan, therefore, was liable to be rejected by the Honorable NCLT under Section 31(2) at the very first instance. The Honorable Court finally held that the impugned judgment passed by the Honorable NCLT in allowing the company appeal of JSW and issuing the directions without any authority of law and without jurisdiction is perverse, coram non judice, and liable to be set aside. The judgments and orders dated 5th of September 2019 and 17th of February 2020, passed by the NCLT and NCLT, respectively, are quashed and therefore set aside. The resolution plan of JSW, as approved by the COC, stands rejected, being not in conformity with the provisions contained in Section 30, subsection 2, read with Section 31, subsection 2. Further, the adjudicating authority, that is the NCLT, is directed to initiate the liquidation proceedings against the corporate debtor BPSL under Chapter 3 of the IBC and in accordance with law. So, friends, we see here that the Honorable Court has rejected the resolution plan of JSWC in spite of huge investments which have already been made, in spite of the time which has already lapsed, in spite of all the approvals by the COC and by the Honorable NCLT and by the Honorable NCLT. Now, what is going to be the ultimate future of this resolution plan of JSW Steel remains to be seen. So, friends, I trust that you find this both engaging as well as interesting. For further insights into such judicial pronouncements under the code IBC 2016, please like this video and subscribe to my YouTube channel. So, friends, I thank you for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.